Today's video focuses on more guarantees that attorneys in New York can make and those they can't make, especially when it comes to negotiation. You want to know what this is about? Come join me for a moment as I share with you a great insight into different guarantees that attorneys can make and those they can't. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. You know by now that no attorney in New York can ever guarantee a particular result or a particular outcome. But there are so many other types of guarantees that attorneys can make. And while I was thinking about this, I thought, how cool would it be if an attorney in their marketing message turned around and said, listen, I guarantee that despite our 200 combined years of experience, it won't mean a damn thing if the defense refuses to negotiate and forces us to go to trial. And you might be thinking, what did he just say? What does that mean? Well, what it means is that many times in attorney marketing messages, they will have a number of attorneys who have many different years of experience, but they will combine them all together to give you the impression that they have huge amounts of experience. And you know what? Maybe they do. But when you add it all up, if a law firm has 200 years of combined experience, is that going to mean a damn thing to you when your case now proceeds through the litigation process and now the defense refuses to negotiate? Hopefully it will mean something when the attorney who is trying your case has significant trial experience, and that will hopefully overcome the fact that the defense refuses to negotiate. And hopefully he'll be able to show the jury that you are more likely right than wrong, that what you are claiming is true, and that all of the harms and losses you suffered are as a direct result of the people you have sued. Only in that instance will a jury then compensate you for all the harms and losses you suffered. But the mere fact that an attorney puts in their marketing message that they have all these hundreds of years of combined experience doesn't mean a damn thing when the defense turns around and says, listen, we're not paying you a dime. You want money? Go have a jury put a value on this case and confirm that we did something wrong. So why do I share this quick information with you? I share it with you because it's an interesting, different look, a different perspective on a type of guarantee that I don't think any lawyer in New York is ever going to make. And why is that? Because I don't think they ever want to come out and say, hey, we give you 200 years combined experience to help solve your problem. But when the going gets tough, now that 200 years won't make a difference. Now we have to rely on our wits. We have to rely on our facts. We have to rely on the case law together with the trial attorney's own experience. Will it make a difference? I don't know the answer to that question, but it's an interesting look at guarantees here in New York. I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're contemplating bringing a lawsuit and you've got legal questions, what I encourage you to do, if you've got those questions, pick up the phone and call me. I can answer those questions. This is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.